Welcome. This is a series of videos to inform the public regarding the truth of history entitled Lies About the Formation of the United States of America. This is lesson number 9, Sedition and Treason, September 21, 1787 through September 27, 1787, written by the Union States Assembly historian and the videos presented by Union States Assembly. This information can also be found on the Union States Assembly website at www.unionstatesassembly.org. We will be doing a brief introduction to some of the basic facts you have not been taught about the formation of the United States of America by the public and private fool systems, which is where Americans get brainwashed and are told lies. In this lesson, we will be looking at several documents, which are the journals of the Continental Congress. These documents can be found on our website as well as at the Library of Congress. It is important to produce these documents in order to prove the truth of what Union States Assembly is presenting. Without such, this could be just another one of those internet speculation videos which many people believe is being true but provide no proof of such claims. Let's get started. On September 22, 1787, the inhabitants of the District of Kentucky vote and approve with the Virginia legislature's consent to turn the district into an independent state and apply for admission into the Union of the 13 states. On September 27, 1787, a day that will go down in history as a day of infamy, Congress deliberates on the presentments from the convention. It is interesting to note that the first act of Congress mentioned in the journals of the Continental Congress for this day is stricken out but still published. See the Journals of the Continental Congress, Volume 33, pages 540 through 542. What stricken out means, in a legal sense, is that it is not there or it did not happen. Let me present it and I will explain why. According to order, Congress resumed the consideration of the form of a Constitution for the United States of America, framed and transmitted to Congress by the Convention of the States, held at Philadelphia pursuant to the resolve of the 21st day of February last, and a motion being made by Mr. Richard Henry Lee, seconded by Mr. Melancton Smith, in the words following: Resolved, that Congress, after due attention to the Constitution under which this body exists and acts, finds the said Constitution, in the 13th article thereof, limits the power of Congress to the amendment of the present Confederacy of 13 states, but does not extend it to the creation of a new Confederacy of 9 states. And the late Convention having been constituted under the authority of 12 states in this Union, it is deemed respectful to transmit, and it is accordingly ordered that the plan of a new federal Constitution laid before Congress by the said Convention be sent to the executive of every state in this Union to be laid before the respective legislatures. A motion was made by Mr. Abraham Clark, seconded by Mr. Nathaniel Mitchell, to postpone the consideration of that motion in order to take up the following: that a copy of the Constitution agreed to and laid before Congress by the late convention of the several states, with their resolutions and the letter accompanying the same, be transmitted to the executives of each state to be laid before their respective legislatures in order to be by them submitted to the conventions of delegates to be chosen agreeably to the said resolutions of the convention. On the question to postpone for the purpose above mentioned, the yeas and nays being required by Mr. Richard Henry Lee, so it was resolved in the affirmative. On motion of Mr. Edward Carrington, seconded by Mr. William Bingham, the motion of Mr. Abraham Clark was postponed to take into consideration the following motion, that is, Congress proceeded to the consideration of the Constitution for the United States by the late convention held in the city of Philadelphia, and thereupon resolved that Congress do agree thereto, and that it be recommended to the legislatures of the several states to cause conventions to be held as speedily as may be, to the end that the same may be adopted, ratified, and confirmed. Keep in mind two things. One, the conventioners were tasked with only revising the Articles of Confederation and Perpetual Union, and not tasked with anything else, and that includes creating a new law form or government. Two, the law of the time is the current federal Constitution, the Articles of Confederation and Perpetual Union. And the only way to alter the existing law form is shown in Article 13, which states, Every state shall abide by the determinations of the United States and Congress assembled, on all questions by which this confederation are submitted to them. And the articles of this confederation shall be inviolably observed by every state, and the Union shall be perpetual, nor shall any alteration at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States, and be afterwards confirmed by the legislatures of every state. Notice that for the law to be changed, it has to first be agreed to in Congress, and then sent to the nations or states, and have all of them agree, not 9 out of 13, as proposed by the treasonous conventioners. Now, let's go back and look at what Congress did first on September 21, 1787. This is the very last paragraph. Congress proceeded to the consideration of the Constitution for the United States by the late convention held in the city of Philadelphia, and thereupon resolved that Congress do agree thereto, and that it be recommended to the legislatures of the several states to cause conventions to be held as speedily as may be, to the end that the same may be adopted, ratified, and confirmed. Had this resolution stood and not have been stricken out, Congress would have properly started the process for a proposed alteration of the law form according to Article 13 by passing it in Congress first before sending it off to the nations or states for their ratification, even though the conventioners did violate federal law, proposing something they were not tasked with, which was to propose alterations to the existing law form and not create a new one. But since it is stricken out, Congress does not give their official approval for a proposed alteration of the existing federal law. The second entry in the journals for this day is filled with treason by all, and it still haunts us to this day, as also the world. See the Journals of the Continental Congress, Volume 33, pages 543 through 544. Motion of Mr. Dane on New Constitution. Whereas, Congress sensible that there were defects in the present Confederation, and that several of the states were desirous that a convention of delegates should be formed to consider the same, and to propose necessary alterations in the federal Constitution. In February last resolved that it was expedient that a convention of the states should be held for the sole and express purpose of revising the Articles of Confederation, and reporting to Congress and the several legislatures such alterations and provisions therein as should, when agreed to in Congress and be confirmed by the states, render the federal Constitution adequate to the exigencies of government and the preservation of the Union. And whereas it appears by credentials laid before Congress that 12 states appointed delegates who assembled in convention accordingly, and who did on the 17th instant, by the unanimous consent of the states then present in convention, agree upon, and afterwards lay before Congress, a Constitution for the United States, to be submitted to a convention of delegates chosen in each state by the people thereof, under the recommendation of its legislature, for their assent and ratification, which Constitution appears to be intended as an entire system in itself, and not as any part of or alteration in the Articles of Confederation. To alterations in which articles the deliberations and powers of Congress are, in this case, constitutionally confined, and whereas Congress cannot with propriety proceed to examine and alter the said Constitution proposed, unless it be with the view so essentially to change the principles and forms of it as to make it an additional part of the said Confederation, and the members of Congress not feeling themselves authorized by the forms of government under which they are assembled to express an opinion respecting a system of government no way connected with those law forms, but conceiving that the respect they owe their constituents and the importance of the subject require that the report of the convention should, with all convenient dispatch, be transmitted to the several states to be laid before the respective legislatures thereof. Therefore, resolved that there be transmitted to the Supreme Executive of each state A copy of the report of the Convention of the States lately assembled in the city of Philadelphia, signed by their deputies the 17th instant, including their resolutions, and the letter directed to the President of Congress. This entry is not stricken out and is deemed an act of Congress. In fact, it is the only official act Congress takes regarding the results from the convention. Let us examine this closely to see where things went wrong. The first paragraph basically states the resolution from February 21 that authorized the convention and what their task was. It was to propose alterations in the existing law form, the federal Constitution, the Articles of Confederation and Perpetual Union, that it was to be agreed to first by Congress and then passed to the nations or states for their approval. The second paragraph says it all. For anyone after reading this to still believe the garbage you have been taught by the Jesuit-run public and private fool systems just means you have been brainwashed and are incapable of seeing the truth. In other words, cognitive dissidence. Because as both Nietzsche and Golden have said, your illusionary powers trumps the actual truth, because you can neither accept it, as it will make you unhappy. You have been indoctrinated beyond repair, or you don't care, which is worst of all. Here is paragraph 2. And whereas it appears by the credentials laid before Congress that 12 states appointed delegates who assembled in convention accordingly, who did on the 17th instant, by the unanimous consent of the states then present in convention, agree upon, and afterwards laid before Congress, a constitution for the United States to be submitted to a convention of delegates chosen in each state by the people thereof, under the recommendation of its legislature, for their assent and ratification, which constitution appears to be intended as an entire system in itself, and not as any part of or alteration in the Articles of Confederation. To alterations in which articles the deliberation and powers of Congress are, in this case, constitutionally confined, and whereas Congress cannot with propriety proceed to examine and alter the said constitution proposed, unless it be with the view so essentially to change the principles and forms of it as to make it an additional part of the said confederation, and the members of Congress not feeling themselves authorized by the forms of government under which they are assembled to express an opinion respecting a system of government no way connected with those law forms, but conceiving that the respect they owe the constituents and the importance of the subject require that the report of the convention should, with all convenient dispatch, be transmitted to the several states to be laid before the respective legislatures thereof. Therefore, the first part repeats the request of the conventioneers, which is a seditious act proposed by the convention on how Congress should do their business. However, it does now appear Congress has read this new Constitution as they do remark about the new Constitution, which Constitution appears to be intended as an entire system in itself and not as any part of or alteration in the Articles of Confederation. This is clearly a violation of the federal law that created the convention, and it is seditious and treasonous. Congress then says of their power, the Articles of Confederation, to alterations in which articles the deliberation and powers of Congress are, in this case, constitutionally confined, and its limitations, and whereas Congress cannot with propriety proceed to examine and alter the said constitution proposed, unless it be with the view so essentially to change the principles and forms of it as to make it an additional part in the said confederation, and the members of Congress not feeling themselves authorized by the forms of government under which they are assembled to express an opinion respecting a system of government no way connected with those law forms. If there was ever a smoking gun to show the treason involved, here it is. Congress sees right through it and what the people of the convention want, which is sedition and treason, followed by a usurpation of the lawful government by trying to bypass Congress on how the existing law form is to be changed, because the conventioners know their proposed changes would never pass the lawful process in entirety. Were any of you taught this anywhere? Why not? Again, the rulers of America cannot rule if the truth be known. The rulers use the Jesuit-run public and private fool system to lie to people and to get them to think what they have been taught is the truth when it is clearly not. So what does Congress do next? Do they do the right thing and expose such a sham filled with sedition and treason? No. They do this instead, conceiving that the respect they owe their constituents and the importance of the subject require that the report of the convention should, with all convenient dispatch, be transmitted to the several states to be laid before the respective legislatures thereof. Congress caves into celebrity. They could not possibly think that all of the famous people in the convention would propose sedition, treason, and a usurpation of not only the lawful federal government, but eventually all of this nation's or states' governments as well. So what really happened on this day? Congress violates Article 13 of the Articles of Confederation and Perpetual Union and commits treason against the Confederation by passing on the proposed new Constitution without officially approving it first because they were afraid to stand up to some famous people. Also, they allowed their own federal law or resolution to be violated and makes no mention of it as well. Did Congress forget their resolution, or was Congress now an active participant in the usurpation? So where do we stand on this day, September 27, 1787? 1. A confederation known as the United States of America is formed in 1781 with 13 sovereign states filled with sovereign people. 2. They fight a war for their independence and win with the help of their allies. 3. They create a lawful law form that still exists to this day and is still recognized around the world. It has never been replaced or done away with. And 4. Congress, in conjunction with the conventioneers, unwittingly commits treason against the Confederation, the nations and states, and the people by violating existing law and proposing a new law form that will usurp the lawful government.